background. So a lot of you may already knew, but in case, this event is co-organized between University of Law with PDVL Overseas Advisory. So PDVL Overseas Advisory, PDVL, established 2007. We have our HQ in Malaysia and our overseas branches in Indonesia, Thailand, China, Taiwan, and Japan. So our network is very extensive. And we basically help students for their overseas education and for their application services that we provide. We partner with top university and professional school in the UK, New Zealand, US, Europe, and so on and so forth for helping students for their further study matters. And we guide students and support students from the very beginning of their education journey until the end. So many of our students, we stay as friends. We help them for their foundation, degree, masters, and even students, they come to us help for the PhD studies. We provide professional complementary services to students. So you can come to us always to ask about the course information and we were giving guidance to students, like if you want to pursue for the law professional pathway, what you need to do, what options of the university available, and we can discuss the financial matters with the student. We help students for the accommodation, not only with the university application, IELTS registrations, and as well, we are the trained visa application agents as well. We help students for your visa application. So this is me. I'm the host for today. My name is MT, Meitin Law. I'm the country manager based in Malaysia. I graduated from the UK, and my major in the university is psychology. I have more than 14 years of the experience helping students for their further studies matter. So I'm also the certified agent and the education counselor to giving professional advices and information guidance to students. So the certificates and the recognition is from British Council and also peer. So this is my certificate. So PDVL have our networks not only in Malaysia, but the other parts of the Asia Pacific country. So Malaysia office, basically, we work very closely with the British Council, UKVI, and our partners, trusted partners in the UK for student for the study matters. So these are the awards that we being awarded by our British Council and also our trusted partners in the past. And for students, it's a fun fact for you to know that all team member in PDVL, you can be reassured that every counselors that you're speaking to or spoke to, we are well trained and we are certified by the British Council. So you know that who is someone that you're speaking to, they can provide you with the accurate and professional information. So this is us. And regarding for the, I believe everyone's here, you have a legal law background. So whether you are in year 2 or year 3 law degree studies, so to become a practicing lawyer, you will need to have a bar vocational training programs later on, continuing after your LLB degree. So these are the bar standard AETOS, the approved education and training organizations in the UK by bar standard boards. So we help students basically to enter to all this. And University of Law, specifically, we work very closely because of their very high passing rates and also good comment from students. So these are the location of the bar programs and the location that you can choose to study for your bar program. And the basic requirement to apply for the bar course, you need to have your law, LLB law degree, and it must be a qualifying law degree. Or you don't have a law relevant degree, you can do a law conversion course. And you also need to be fluent in English, equivalent to the IELTS 7.5 band overall in each of the components. Or there are other methods as well to assess your English. And as well, you need to be a member of the Inns of Courts. There are 4 Inns in London. With us, PDVL, we guide students and we already assisted students many years and many intakes for hundreds, thousands students for their bar education, bar program application. So what you need to do, you just deal with us and very as simple as come to us, discuss about the bar programs, the location, your budget, and we will help you to analyze the best bar school for you and help you to apply to the bar school directly, guide you how to prepare for the documents, and then later on help you for the application, deal with, follow up with the bar school. Coming, if you get the offer, we will help and guide you for the offer acceptance, and then later on helping you for the visa. So these are the services that we provide to students and can be categorized on pre-application, post-application, and then extra offers that we can provide to students. Of course, student, you can choose to apply to bar school, bar program by yourself, but there are a lot more that you can enjoy as our student. So we're looking for the September intake. You're still in time to apply for the bar programs. So applying, get the offer, and then we will guide you step by step, basically. Our services is free and recommended by all our past law students and parents. All these are the 5-star reviews that our students and parents that left to us. So very quickly, I would like to introduce Nigel. Let me talk about Nigel profile and background. Nigel is program and student leads, and he is now based for the BBC Bar Professional Course Manchester and Liverpool campuses at University of Law. He called to the bar in 1994 by Gray's Inn. So after call to the bar, he practiced at the criminal bar from Champos in Manchester for 20 years. And later, by the opening of the ULaw campus in Manchester, he joined the Manchester campus and become the lecturer and to teach in criminal skills, litigation, evidence, and sentencing. So we can see that criminal is the expertise area for Nigel. He also designed updates for the PC manuals and criminal skills course, and he also designed a moderated PPC assessment at ULaw. In 2022, Lord Ledge also published Nigel books in the title of Life as a Junior Barrister in the Words of the Independent Bar. So a lot more about his books and the publication. So without further ado, I would like to invite Nigel, and I will pass the time and for you to talk to students. Thank you. And let's everyone to have a warm welcome. Thank you.
Hello, everybody. So welcome to our taster session on criminal litigation. So here's my plan. I thought we might do the criminal litigation part first, because I think that's going to be quite fun. And then I'm going to talk a bit about the bar course that we offer at the University of Law and how it's structured, what you can expect, the sort of class sizes and so on. And I'll talk about the a couple of handy tips that I would suggest you consider engaging in, and that you can start perhaps even now in readiness for coming on the bar course. Grand. So let me share my screen. Now, we're going to do a little presentation on Mentimeter. And I don't know whether any of you have had experience of Mentimeter before. It is quite fun, actually. So what you're going to need to do is, I don't know if you're on your laptops now, either open another tab on your browser so that you can access the Menti slides, or if you have a phone handy that can connect to the internet, maybe use that as your second screen, because you can see the screen I'll be sharing on the big screen just as you can now, but you're going to vote and input information that will register on the screen. No one can see who's voted for what. That's not the point of it, but it's quite fun, I think, to see how that works. So MT, I think we put in the chat, didn't we, how people can log on. So if everybody's able to open the chat, can you see, I'd like you to visit www.menti.com. And when you enter that website, it will prompt you to enter a code, which will bring up these slides on your screen. And there's the code in the chat, 4888-6287. So that's the plan. And if you're able to log on and enter that code, you'll be able to take part in the presentation interactively. Of course, I can see on my screen here, I can see some thumbs ups coming in the bottom corner of my Menti screen. So people are logging in and managing it, which is great. I mean, you're probably used to Menti.com, you know, but even if you're not, it's quite straightforward. All right, so what I'm going to do then is share my Menti screen on this big screen here, and we'll start going with our criminal litigation taster session. And when I was considering how to do this and what topic to choose, I thought I'd go in big. So what we're going to look at is the topic of hearsay, which is a topic traditionally, I mean, we spend 2 workshops on it because it's quite complex. And to get your head around it, it's rather more challenging in the detail that the bar course requires. But let's begin and have a look at what the hearsay rule is in criminal litigation. So we can skip over this slide that just shows me, we know what I look like. And that's not very interesting. But here we are. So here, you're able, I think, to input your thoughts. So would any of you like to contribute an answer to this question? When you think about criminal litigation, what emotions do you feel? Yes, that's a good one. I like that. Thrilling, yes. Do you know what? I actually do find criminal litigation very interesting. Scary, yeah, I get that as well. Good. So some really good thoughts coming in there. And I probably agree with all of those. So some parts can be heavy. I completely agree with you. But people tend to go through a stage where it's rather challenging, but then suddenly it clicks up there, you see, and then you're in with it. So all those absolutely right. I agree with all of those. So let's move on to our next slide. Now, we're going to learn about the hearsay rule, like I explained a moment ago. But I'd just like to get a feel for this among you. Do any of you actually know what it is? Some of you may have studied it, of course, to some degree. Oh, maybe a little. That's good. Grand. I love this. I love this. We're going to have such fun today. Okay, that's useful. Thank you very much indeed. So let's move on to our next one here. So this is to get grips on what hearsay is. We're going to start with what we all recognize to be a traditional court scene. So there you have the judge, and there you have the barrister, and there you have the witness in the witness box. And I guess on the right of the screen there, we can see two members of the jury. So we're in the Crown Court, looking at the style of dress that people are wearing. And that's what we imagine, don't we? We imagine that you're the advocate and you're calling a witness who goes in the witness box and says to the jury, this is what I saw, this is what I heard. And you're calling them as a witness to help your case. So that's traditionally what we understand an English criminal court case to be like. And we see that replicated in many court centres across the world. That's the straightforward part. And it still happens like that, mostly. And what we see in that traditional court scene is the witnesses in court, and they are making statements to the jury in court about what they witnessed. I saw this. I heard this. This is a document I created. So we're going to think of an example now. So you're the advocate, and perhaps this is a robbery case, and you call the witness and you say, when you were chasing the robber, which way did you see him go? And the witness answers, I saw him turn right into Market Street and I followed him. That's grand. Yes, there's always a but. Yes, in criminal litigation, there's always a but. And what you'll find when you study criminal litigation typically is, here's a rule. That's great. But here are all the exceptions to the rule. And then you factor those into your understanding and you realize that none of it really makes much sense. And that's what we're going to focus on. Problems arise. Imagine that traditional court scene. If you want the witness to tell the court about a statement made by someone out of court. So let's just think about that. And the emphasis here is on out of court statements. Not like before, our traditional court scene, where the witness is in court saying in court what I saw and heard. Here, they're telling the jury about something someone said out of court. And this is the part where it gets slightly fantastical, because you can only really understand this once you realize that there isn't really anything sensible here. You just have to know what it is you're seeing. What do we mean, first of all, then, by an out-of-court statement made by a person? Because that's what we're dealing with. So we'll put that into an example context. When you were chasing the robber, which way did you see him go? And we imagine our witnesses saying something like, I didn't see, but a woman pointed up Market Street and shouted, he went that way. So that's our factual scenario. So we're going to come to a question. I didn't see, but a woman pointed up Market Street and shouted, he went that way. And my question to you is, how many out-of-court statements by a person are contained in that evidence from the witness? So have a guess. You can vote for none, one, or two. So don't worry about getting it right or wrong. This is, after all, just a bit of fun, and no one knows how you voted anyway. I didn't see, but a woman pointed at Market Street and shouted, he went that way. So we're having a bit of a race on here between 1 and 2. 2 slightly edging it. Someone's there on 0 out-of-court statements. Oh, okay then. Oh, double 2 now compared to 1. Right, thank you very much. So let's look at this a little bit more. A woman shouted, he went that way. So this is an out-of-court statement made by a person because the words, he went that way, were spoken by someone outside the courtroom trial. So that is an out-of-court statement by a person. Some of you, I think, spotted this. This also is a statement. There are no words accompanying it, but it's a statement. Someone is pointing and communicating information to you. They're making a statement to you. with their body. So here we come to what a statement means. Any representation of fact or opinion made by a person by whatever means. And the last bit, just for clarity, makes clear that some aspects of life amount to statements. So pointing is a statement. Good, and that Criminal Justice Act 2003 we see just there is the main statute now that deals with. So can everyone see the, is that coming up empty? Empty?
Yep.
Brill. Okay then. So out of court statement made by a person. We remember, I didn't see, but a woman pointed at Market Street. He went that way. And we had the most votes were 2, because of course, he went that way is an out of court statement, and pointing is also a statement. And here is our definition of statement. Any representation of fact or opinion made by a person by whatever means. So we have our statement made out of court by a person. Got that. But where's the problem? Now, what was the purpose of the person when they made the out of court statement? So we're going to look at the woman pointing up Market Street and saying he went that way. Now, if you didn't vote on this, have another go. Did the woman intend the witness to believe that the man did go that way? Yeah, absolutely. The second question you need to ask is, what is your purpose? So you, the advocate, what is your purpose in wanting the witness to tell the jury about the out-of-court statement? Is that statement only any good to you if the jury accept it as being true? So imagine you're calling the witness to say, the woman shouted he went that way and pointed at Market Street. Do you want the jury to conclude that the man really did go up Market Street? Difficult because, of course, we don't have the whole context of the case, but we're assuming it's important that the jury should know where the man went because it's about catching the robber, in which case, if that's so, it does matter that the jury accept it as being true. The witness can't say for himself or herself in which direction the man went. In fact, you, the advocate now, you're relying on the woman's words and actions as being true because there's no other evidence as to where the robber went. So we've got yes to the question that you want the witness's words to be true. And we've got a yes to the question that the purpose of the woman in saying went up that way is that they should be accepted as being true. So here's why it all matters. Because the rule against hearsay stops you, the advocate, asking the witness to tell the jury what the woman did and said. Unless you can find an exception to the hearsay rule. So we're not going to cover exceptions to the hearsay rule today, because that's a whole workshop by itself. But an out-of-court statement made by someone which they intend the other person to accept as being true, and which you, the advocate, you want it to be true as well, because it helps your case if it's true, well, then the brakes come on. And English criminal litigation rules say, stop, consider please, you need an exception, because on the face of it, you're not allowed to introduce that evidence. All right, so we've now got to a point, I hope, where you're able to understand how to identify hearsay evidence. And you understand that it's not normally admissible unless there's an exception. So slightly interrupted by the lack of reception, but that's how the English litigation rule of hearsay operates, and which takes the shape of a workshop that you study on the criminal litigation module. You might wonder to yourself, why does it all even matter? And that's a very good question, because there was a House of Lords before the Supreme Court. The highest court was called the House of Lords. A House of Lords decision in the case called Kearley in the early 90s, in which a minority of the members of the House of Lords said, what is the point of all of this? Just everyone should know about it. Good. So that is hearsay in the English criminal litigation rules. Here I am. That's the end of our criminal litigation taster session. So MT, what I was just going to go on to do now was talk a little bit about the course, the bar practice course. Is that a good idea?
Yes, Nigel.
Okay. So I'm assuming people can still hear me. I can see my video keeps going off, which is slightly annoying, isn't it, really? But we all know what I look like anyway, because I was on that picture earlier. So I'm going to assume people can hear me. So let's talk about how the bar practice course is arranged. And I've got some slides I could show you, but I prefer the way I describe it, actually. Think of the bar course as being divided into 3 parts. The first part are what we call knowledge skills. The second part is what we call written skills. And the third part is oral skills. And you take assessments in each of those 3 subject areas. So in the knowledge skills section, you have to learn the rules of criminal litigation, evidence and sentencing. You have to learn the rules of civil litigation. And you also have to learn the rules relating to ethics. And we give you workshops in ethics at the beginning of the course, and there's the refresher workshop a bit later. But criminal litigation, civil litigation, their workshops continue throughout the whole course. 2-hour workshop in each of those every week on the course. And that's because there's a fair amount to get through. And we give you Blackstone's criminal practice, which is the set text of crime. And we give you the white book, which is the civil litigation collection of rules. And the skill in passing those exams, they're multiple choice exams or single best answers. Can be quite tricky. Maybe more than one answer is technically right. You've got to choose the best one. The skill in passing those is to have a thorough understanding of the rules and to keep it going through your head as the course goes on. So they're the knowledge exams. Next, let's take written skills. So in particular, you need to learn how to draft legal documents. So we teach you that in our drafting workshops. And you need to learn how to write what we call an opinion, which is typically your advice to your instructing solicitor in a civil case on typically the chances of success. So the case papers might say, we act for such a person who suffered such an accident at work with these injuries. Can you please advise on the chances of success if our client launched a legal action against his employer? And we're looking at how you structure your opinion, whether you research the right areas and include the right advice. And we also ask you to submit a legal research trail showing how you got to your advice. So there are 3 exams there: drafting, opinion writing, legal research. And they're the written skills that the Bar Standards Board say you need to learn about. So far we've covered knowledge skills and written skills, and that leaves the oral skills part. And this is sometimes the part of the course that newer students take a little time to adapt to. And I understand that, because this is, if you like, performance. So you will take exams in conference skills, where we have an actor in to play the part of the client, and you have to give advice and take instructions in a 20-minute conference. You will take exams in examination in chief of a witness and cross-examination. So examination in chief is where you're asking questions of your own witness to get their account before the jury. Cross-examination is where you're asking questions of the other side's witness. And the purpose there is maybe to undermine their account or to show why their evidence should not be accepted by the jury. And also you'll take a civil advocacy assessment, which is submissions to a judge. So you'll have some case papers, you'll do a skeleton argument that you'll submit to your assessor in advance, and you'll turn up and you'll supplement those written submissions by making oral submissions. So that's the structure of the course in terms of how you study and the assessments you take. Just a little word on the oral assessments. It can be quite daunting to turn up, for example, to a workshop on criminal skills and find that you have to stand up and do a 10-minute questioning of a witness in the workshop. We understand that is a bit daunting, but we do everything we can to help you adjust to that. So rarely, if ever, would you do an examination in chief just you in the room. There'll be typically a group of 6 students. And these will be 6 students who you've got to know well through the course anyway. And you will each help each other. You'll each in the workshop play the witness for each other, as well as being the advocate. And we'll all be able to give feedback to each other. So these are quite informal sessions in that they're friendly and fun. But also, we want you to know what the rules are, and we'll give you good advice as to how to improve. So the best advice I give students for the oral skills sessions is try not to be afraid, keep your voice up, sound strong, and put into practice all the questioning skills that we've been teaching you as the workshops have gone on. And you'll adjust to it pretty quickly, I promise you, and it won't hold any form of concern. But you're among friends. We're all friends. People make friends on the bar course that they keep throughout their life. I know I did. I did my bar course back in 1993. And I still keep in touch with people who I got to know then. And, you know, you lose touch with people, and then later in your practice career, find them again and say, oh, I remember you from the bar course. So bar courses are fun, and they're quite intense. It's worth saying that. And to some extent, it doesn't matter which provider you go to. It's an intense course. It's hard. It's the most work we do. So that's how the bar course works. We saw a little slide earlier, didn't we? I think MT showed it on where University of Law have campuses. We have them across a wide part of the UK. So Manchester and Liverpool is where I am. Hello, MT. Am I running to time?
You're still fine. You can carry on.
Sounds good. Jolly good then. So yes, I'm at Manchester, Liverpool, and I practice as a criminal barrister for 20 years in Manchester and Liverpool mostly. Most of the lecturers either are or were practitioners. So it's no use teaching you theory. You'll do a lot of theory and principles in your LLB, and that's valuable. But on the bar course, it's intensely practical. That's what you need to learn. And learning from people who've done the job is the best way we find. So we're Manchester, Liverpool, we're in London, we're in Leeds, we're in Bristol, we're in Birmingham. All places offer the full-time course, the one-year course starting in September. Some campuses, not all of them. I know at Manchester, Liverpool, we don't. Some campuses offer the part-time course that takes 2 years and you study it at weekends. And other campuses as well offer the full-time course starting in January or July. But the full-time September start course is the most popular. It's the one that most people go for. I just talk a little bit about selection events. Not every provider of the bar course has a selection event. We do. We require that applicants get a 2-1 in their first degree. If you get a 2-2, we'll still consider you, but that requires special consideration. But if you get a 2-1 and you pass the selection event, you're in. And that's important, I think, because being selective means we're taking a larger slice of the students who are most likely to do well. So if you come to the University of Law, you'll be working alongside other students of a similar mindset to you who are, in our view, in the selection event, most able to succeed, most committed. Don't worry about a selection event. There's a 5-minute advocacy exercise, but we give you all the material that you need. And we don't expect you to be the world's best advocate. You're coming on the course, aren't you? You haven't even started the course yet. So we're looking for the raw material. Do you have that? The raw material to succeed? And have you thought about why you want to become a lawyer? So expect sometimes the obvious questions as well. All right, scholarships. Just 2 words about scholarships, really. Firstly, you know you have to join an inn of court. There are 4. I joined Gray's Inn. Doesn't much matter which inn you join. They all offer a good service in helping you with events throughout the bar course year. They're all good at that. They all have scholarships available, and some have scholarships that are more directed to certain categories of the population, and other inns will have scholarships directed at other categories of the population. So my suggestion is have a look at the scholarship offerings by the inns and consider if you want to apply for an inn scholarship, which one might be best for you. You need to apply a year before you start the bar course there. Similarly, University of Law, we offer scholarships as well. Yeah, there's a lot of money available there. And you would apply for a scholarship at the point when you apply through the website to come on a selection event. The sooner the better, because there are closing dates for the selection event. For the selection events and also for the scholarship application. So don't delay. You can make your scholarship application anytime you like. The sooner the better. And I'll tell you why. Because when you get your approval to join the bar course, from that point on, you are able to access the employability service at the campus you're going to. And they're good. I know Manchester, Liverpool better because I've been working there for nearly 5 years. They are excellent. They'll help you with your CV. They'll do practice interviews with you. They'll talk with you. You'll discover things about yourself that help you in job applications that you didn't even know yourself. That's how good I think they are. And you cannot start too soon. So access employability really long before you begin the bar course. Please do that, it will help you. And if I may, two last bits of advice, and MT knows about these because I talked about these when we did an event in Chester. Firstly, if you're not on LinkedIn, get on LinkedIn. Aspiring barrister, something like that. Have a profile with a professional picture and tell details about yourself that are relevant. If you do things, if you attend events, if you go to a chambers, if there's an event there, post about it. That's the first thing, be visible. Second thing, when you're in the UK to start the bar course, go to courts. Watch what goes on. Apart from family courts, you can pretty much go in any courtroom you like. Sit in the public gallery and observe. It's brilliant. If you want to be a doctor, you can't walk into a hospital and say, I'd like to watch this operation, please. They won't let you. They won't let you. But if you want to be a barrister, you can go into a court anytime you like and watch barristers doing the job and just soaking up the atmosphere and the language, the way people speak with each other is so valuable. And do that before the bar course, the best preparation, honestly. And you might make some connections with members. Yeah, well, if you want to do an LLM alongside the bar course with us, you can. There are three. There's a choice of three. You can do what we call optional modules. So you can choose two subjects that are new to you to study. For example, international criminal law, mental health law might be ones that I would choose. And you start studying those after the bar exams are finished. And you take exams in those at the end. So that's good. Other two routes run alongside the bar course. So we have pro bono, where you would go to events. You don't know whether MT in the chat there's any questions that I can help with.
We welcome students. If you have any questions relating to criminal litigation, you can just post on the chat, and we will pick up and answer student accordingly.
Okay.
But there's one question asked in the chat already, and student Priya asking what happened if students obtain third class honors.
Yeah. Well, it's not out of the question that you could start the bar course. Students with third class honors just need to cross an additional hurdle first, which is to approach the Bar Standards Board and apply for a special permission. I can't remember at the minute what the wording is, but you need to get permission from the Bar Standards Board to begin a bar course. And once you get that, then the application will come to the program lead for the campus that you're applying to, who will consider whether to offer you a place. So it's not out of the question. My worry is that a candidate who obtains third class honours, that might be an indication that perhaps something as rigorous as the bar course might not be for them. But that doesn't always follow, of course. We do find students who do well in their first degree always do well on the bar course. Okay, so I hope that helps. I can see something here about mitigating circumstances. Okay, like family passing, falling ill. Yeah, we do. I mean, if something like some enormous life event such as that has affected your degree result, well, then that would be considered. We always consider it. And you have an opportunity, say you get a 2-2, to give any explanation that you think we should be aware of when we're considering your application to come on the bar course. So yes, absolutely. We do consider those. Oh, now that's a good question. The biggest challenges faced by international students and how can we prepare for them? Okay. Well, I talked a lot about this. I talked a lot with my students from Malaysia the last couple of years about exactly that. And I think the best answer I can give you is in terms of the way of learning. This is not a course. The bar course is not a course where the lecturer will give you all the information that you need. It can't work like that. There's too much material. We could not, in all the workshops, cover every piece of material. So the strategy that we have is you will have some reading in advance of the workshop, and you'll have some preparation tasks that help to get an understanding in your head about how that topic for that week works. And the purpose of the workshop is to deal with the difficult areas, to make sure that people understand those, and to give everyone the opportunity to ask questions and develop their understanding better. So the emphasis really is on the student actively going out and learning. Don't to be told everything that you'll need to know for the exam. So that is what students of mine from different countries have said to me is sometimes the best advice to give people. It's also why I dealt a few minutes ago in my little talk about the bar course on the oral skills. People can be worried about that because standing up, if you like, because we do stand up with lecterns to do the evidence in chief and cross-examination, it can be quite intimidating at the start. But sometimes you've got to force yourself to get through that in the comfortable surroundings, a safe environment of people who we know on the course and who will be looking out for us and helping us. So I hope that helps, Priya, with the question that you're asking. They're exactly the sorts of concerns that students from other countries have brought to me. And if I'm being honest as well, students from the UK can have the same issues. Forcing yourself to get over those hurdles is the trickiest bit. Do employers or chambers show a preference for graduates from specific bar programs or locations? Oh, gosh, probably my only answer to that is I don't really know. Don't really know on that one. I mean, there are different providers. They structure their courses differently. So if you're considering a different provider, you need to look at whether their course structure is best for you. I mean, we teach skills for criminal alongside the same subject for civil litigation. And then we have criminal litigation, and the same week you'll do a skills session on the same sort of topic. And we think that doing the knowledge and skills together as much as we can through the course helps it to go up here. That's the structure that we have. Specific ins better suited for international students or those interested in criminal litigation. Honestly, I don't think in that respect some ins are better than others. The reason I chose Gray's Inn was because when I did my law degree, I was in London, at King's College London, which was close to Gray's Inn, close to all the inns, to be honest. But someone said to me that Gray's Inn had a good library. And back in 1993, nothing was online, of course. And that was enough to persuade me to go for Gray's Inn. I mean, what a rubbish reason that is for choosing one inn over another. I wish someone had said to me, think ahead and look at the scholarship offerings. I didn't really know about scholarships. And go for the inn that maybe offers you the best chance of getting a scholarship. So I don't know. There isn't really any difference in the inns, to be honest. And in terms of the service they offer to you as a bar student, they're all good. So don't spend much time over that decision, would be my advice. How is the field of criminal litigation evolving in the UK and what skills are becoming increasingly important? Wow, that's like an interview question, empty. How is the field of criminal litigation evolving? Well, criminal litigation generally, to be honest, has changes incrementally. There aren't any mammoth changes. And generally, it's the same as it always has been. There are some changes, we have, since the 1980s, witnesses have been able to record their evidence in certain cases, so they don't have to give evidence in chief. You simply play the recording. There's a development now where some cross-examinations are even recorded and then played at the trial, much, much later. But the skills that we teach on the bar course about examination and cross-examination of witnesses in criminal work are fundamental and have always been. And I think, certainly in my lifetime and yours, they always will be. I don't think we're ever going to get to a stage where the oral skills are going to be diminished for criminal work. Are the criminal civil subjects taught in different semesters or are they combined? They are combined. So we have 2 semesters, September to December, and the other one January to about April, finishing off then going into the exam season. And you have civil litigation alongside criminal litigation. So you have a workshop in criminal lit, 2 hours, civil lit, 2 hours. And generally speaking, 2-hour civil skills and a 1.5, 2 hours criminal skills, depending on what we're doing that week. So from that perspective, 2, 4, 6, 8 hours worth of workshops in a week. Doesn't sound much, but there's a lot of work, a lot of prep work, and we give you consolidation work afterwards. So after the workshop, do extra practice to seal the knowledge in, do everything we can. And students who I've had, certainly in the past, have said that that helps them because civil and criminal are different things. Example, there's rarely examination in chief in civil cases, I understand. So examination in chief is predominantly a criminal skill, increasingly. So that's one difference. But studying them alongside each other helps to show how they're different and also why they're different, and helps with your understanding, is what students have said to me previously. Do we provide accommodation? Well, we have accommodation services. I don't know that they would go out and find you somewhere to live. Don't know that. But certainly we have an accommodation service who can help accommodation. Yeah. Oh, there you are. MT. Yes, I can see that there. Good. Yes. Oh, yes, exactly. MT. You can help as well. That's brilliant. The limits on imprisonment in the magistrate's court, the current maximum is 6 months. I don't. Well, what aggregate term means? Wow, that's offences triable either way. Well, now that is, oh, that is a complicated-ish subject because the maximum sentence is actually 12 months that the magistrates can impose. It was for decades 6 months, then it went up to 12 months not long ago, then it was brought back down to 6 months, but now, about maybe a month ago, it went up to 12 months. So that's really recent news. So it's been a bit of a yo-yo, that one. So yes, for either way offences, magistrates can impose a maximum of 12 months. So only if the offence is worth more than 12 months can it go to the Crown Court by the magistrate's direction. Because it's either way, the client always has a say-so on, I want to go to the Crown Court, and that's decided. An aggregate term when it comes to offences triable either way. Yeah. Oh, actually, I see your question. The maximum sentence is 6 months for a summary-only offence. Okay. But yeah, listen, we can have a whole workshop on that. How long have we got? But an aggregate term generally means the overall term that someone would serve. So you might get 6 months imprisonment for this offence, 12 months of that offence. They might run concurrently, so alongside each other, maximum 12 months, or they might run consecutively, so 6 months followed by the 12 months, making 18 months. So the aggregate term is really the overall figure. This question here, AI continues to evolve. Key skills and qualities. Well, these are the key skills that we teach you on the course, to be honest. The ability to communicate information is utterly key. That's absolutely key. I did a lot of drama when I was a child growing up, and that helps. The ability to having that confidence to talk to people is a key skill, and that helps you to communicate ideas from here into someone else's brain. That's the ultimate skill, I think. AI, yeah. That is a hot topic, actually. In fact, is my book here? I don't mean the book I wrote. I mean, I can't quite see it on my shelf at the minute. There's a book. Richard Susskind does some books on legal technology, and they're well worth a read. I think we're a long way off AI replacing lawyers. I don't think criminal lawyers or civil lawyers are going to be out of a job anytime soon. But I do think there is this risk that lawyers who fail to embrace what AI technology can do for them, they're the lawyers who are going to be left behind. So I think learning about AI and how it can help you be a better lawyer to your clients is important. But focus on the bar course. I would recommend Richard Suskind's books on how AI and technology helps in the courts. Okay. MT, how are we doing? I think I've tried to deal with I think everything in the chat. Is there anything else that we can cover?
I think you already answered all the questions posted, but let's see any questions coming up from students.
We actually had good questions, Nigel. Yeah, the students. Yeah, very good questions.
Very good questions. I like very forward thinking, actually. Especially the question about skills for lawyers and AI. They're actually, if I may say, they're the marks of really good students. They're the indication that the people in this group today are going to do well because you're thinking ahead. And that's a really good thing to see. That's great.
Well done, students.
I have one more question from student asking about this. How does one handle a case that has immense public pressure to secure a conviction, but yet the evidence is inconclusive? What are the balance that had to be struck when faced with these dilemmas?
Yeah. Tricky.
Very deep.
Yeah, and sometimes you have a situation where maybe you aren't so convinced about the case that you're being asked to present, but you're instructed to present it anyway, and that happens. The best advice I can give you is your views don't matter. Harsh to say. I would hope that with your client, you're frank and you're very clear in giving your advice, perhaps that their case is a weak one, and you'll explain why. But ultimately, the client's in the driving seat. If the client wants to launch a legal action, whether it's bring a civil case against somebody, or whether they're charged with a criminal allegation in the criminal courts and they're telling you they're not guilty for whatever reason, it's your job as an advocate and as their advisor to give them honest, straightforward advice. And if their case is not good, you'll need to tell them. But like I say, the client's in the driving seat. If they say to you, Mr. Booth, thank you for your advice, but we still want to go ahead anyway, well, then that's their decision. And you will do your best for them within the rules, obviously. Of course, within the rules. But generally speaking, in my experience, courts get their decisions about right. Sometimes I might not agree with the decision, but I can understand why the court has come to that decision. And ultimately, mostly it will come around like this. If a client proceeds with a case against your advice, more often than not, it won't work out well for them. But you do your job. You do your job properly. And sometimes you'll succeed in cases where you've advised that the case didn't stand much of a chance of success. And that's just the way the dice roll, I'm afraid. And that's just life. So I hope, MT, does that go some way to dealing with what you were answering, what you're asking about? It's to do with your professional duty, isn't it, I suppose, for your clients, and your own opinions about whether they're right to bring the case or not don't really matter.
It's a question from student by a student sent to me.
I see. Oh yes, I see. How does one handle a case? Immense public pressure. The evidence is inconclusive. Yeah. So I suppose that's I understand. Yes, that's more of a criminal aspect, isn't it? So you're prosecuting a case, but the evidence seems inconclusive. Well, slightly different scenario there, in that a criminal case should only be run if two statutory tests are satisfied. So the Crown Prosecution Service must consider, is there sufficient evidence of the charge, and is it in the public interest to prosecute? And if the answer to those two questions is yes, you should expect that a prosecution will follow. I suppose perhaps they approach it this way. It's not a great prosecution case, but there's maybe more than a 50% chance of success here on my assessment. In which case you should expect the prosecution will be brought if it's in the public interest. But then, you see, fast forward to the trial process, and the jury convict only if they're sure of guilt. Not if they're 51% thinking that there's guilt. They have to be sure of it. So there's a slightly different standard there. But you might say there's a relatively low threshold there for bringing a prosecution, if those two tests are satisfied. So is the evidence inconclusive? Well, the trial will have to determine that, I think. And public pressure, yeah, you do deal with public pressure sometimes. Sometimes the reporters will be there. I've been outside court where they've been interested in the case that I've been in, and they've taken my photograph going in. I don't know why. Never used it. But yeah, that's so. But the way to handle that is, it sounds maybe easier said than done, but you put it out of your mind, really, because once you get into court and you've got the wig on and you've got the gown on, the evidence is waiting, the witnesses are there, you're prepared whatever speech you're giving, you know where the questioning is going, the professional part of you just takes over, and any pressures that you might feel tend to dissipate away as you just deal with the job and do the job. Pupillage process. It is competitive. It's very competitive. There are, strangely, a greater number of pupillages available now than there used to be. Certainly, I think coming out of COVID, COVID took a bit of the bar took a bit of a dip maybe with pupillages, but especially in criminal work, there's a need for criminal barristers. So the chances are perhaps better than they ever have been. For international students wishing to practice in the United Kingdom, I think you'd need to get sponsorship. I think I'm right, MT. Is this right? You'd need to get an organisation to sponsor you to work. I don't know if chambers do that.
Malaysian student, if you successfully completed the bar programs, you can apply for a visa called graduate route visa that you will get 2 years stays to in the UK, and you can use the visa to apply for the pupillage.
Yeah. Good.
This question asks, what can we do to increase our chances?
Yeah, okay. Okay, so firstly, you will develop an idea, if you don't have it already, as to what area of law you'd like to practice in. As the bar course goes on, people tend to get firmer and clearer ideas about that. On social media, and there are various ones available, Blue Sky, interestingly, seems to be taking off among lawyers. Social media is a good place to do your research. I don't necessarily mean to post. I mean, do your research into chambers, into barristers. LinkedIn is a good resource. See what chambers offer. Often they'll be giving student events. They're keen to attract the best students to their pupillage application procedure. So keep an eye open. Actively seek out pupillage events that chambers put on and go to them. Some will be online, some will be in person. Go to as many as you can. Find out about chambers. Go to court and watch. Make connections with barristers. If you meet a barrister at court, follow it up by a message on LinkedIn or email their chambers and say how much you value coming. And ask them some questions. They won't think that you're being a pest. They'll be pleased that you've taken an interest. So that's one thing you can do to increase your chances. The second thing is during the bar course, I know at Manchester and Liverpool, this is what we arrange, and other campuses do exactly the same for the University of Law. We have events where we have barristers coming in and talking to you, having little workshops with you, not just lectures, but events. Interactive events to talk about the bar, to meet you, to give you a chance to ask questions, to make connections. Go to all of those. Even if it's a barrister talking about an area of law that you have no interest in, go anyway. Get the exposure, because the bar is a small world. It's so curious for this. Who knows? You might end up being interviewed at a chambers for pupillage by someone who you met at one of the events at University of Law. And you might be doing a criminal pupillage interview. They might be a family practitioner sitting in on the interview process to give some objectivity. That's quite common. So make connections and keep a note of who you've met. Keep a note of things that you've done, events that you've gone to. Remember names. If you do something and it's quite interesting, make a note of it, because you'll be asked questions in pupillage interviews about competencies. Tell me about a time when you've had to display leadership in an unexpected situation. Tell me about a time when you had to convince somebody to do something which initially they didn't want to do. Things like that. So if in your dealings with people in ordinary life, you do something like that and you think, oh, that's a skill that a barrister uses, make a note of it and have it a central place where you keep those notes, because you'll forget. You'll forget what they are. The details will fuzz. As you do the bar course and your brain gets full of hearsay and bad character and criminal litigation, you'll forget what those incidents are and you'll be glad you made a note. Because it's those examples of how you put interpersonal skills into play that you will deploy when you are interviewed for pupillages. So it's not really about 2 weeks before the pupillage interview, how best do you prepare? Because that's too late. It's about preparing now and gathering your material together that you will choose from at a later date when you go to your pupillage interview. That, in my view, is the single best thing you can do to improve your chances further down the line. It's odd because you're preparing now for something that's not come about yet, but it's the best way. So that's my answer to that question about how to increase your chances. That, and right now, I'll say again, first chance you get, go into courtrooms and observe. Spend the whole day there. Take your lunch. Sit in the court canteen between 1 o'clock and 2, and then find a different courtroom to go and sit in for the afternoon. Seriously. If you remember one thing of anything I've said today, let it be that. That's the most important.